The broadcast is now starting. All attendees are in listen-only mode.
Alrighty, thank you everyone for participating today. Welcome, and thank you for attending the Colorado Podiatry Board Stakeholder Meeting via webinar today. It is September 22nd, 2020, and the time is 3 p.m. Before we get started, we would like to introduce the staff members from the Division of Professions and Occupations that are present. My name is Darcy Magnuson, and I'm a regulatory analyst with the division. Also attending is Karen Phelan, Program Director, and Elena Kemp, Regulatory Coordinator. We'll be facilitating this stakeholder meeting. In compliance with the governor's orders regarding COVID-19, the division has transitioned to a platform that is 100% virtual, and we appreciate your flexibility. As many of you have been to DORA stakeholder meetings before, we would like to reiterate the importance of your comments today. DORA makes decisions every day that may affect your life and your business. Your input is vital in the rulemaking process. Throughout this process, our goal is to create regulations that clarify and explain legislation, ensure minimum competency to enter and continue to practice, and provide only what is absolutely necessary for consumer protection without creating unnecessary barriers to the marketplace. Your input will be part of the information that goes to the board as it considers adopting new rules. More specifically, we'll be discussing the proposed new rules 16.1, 16.2, 19.1, and Appendix A to implement Colorado Senate Bill 19079 concerning the requirement that certain practitioners prescribe controlled substances electronically, and Senate Bill 20102 concerning patient disclosures regarding sexual misconduct. This meeting is being recorded and will be posted on the board's website at a later date. As this stakeholder meeting is held solely by webinar, please raise your hand by using the hand icon if you would like to speak, and we will unmute your line so you'll be heard by everyone. Or you can type your comment in the question section and we will read it aloud. For anyone that is planning to provide comments, please state your name and who you represent. Feel free to provide either general comments on the new rules or specific comments on the proposed language. Keep your comments limited to 3 to 5 minutes or less, and try not to repeat something that was already said. Stating you're in full agreement with someone else works just fine and will be noted. If you are using the audio through your computer, please remember to put any phones on vibrate or turn them off. And whether you are using computer or phone audio, try to keep background noises to a minimum when speaking. At this point in time, we will open the floor for feedback. We'll start with new rule 16.1 regarding the electronic prescribing of controlled substances. If anyone wants to provide any input on that new rule, you can raise your hand and we'll unmute you, or you can type in a question and we can read that out loud for the recording and for those other people who are participating. After we go through this rule, we'll jump to the other new rule. So I'll give you a couple of minutes. I don't see any hands raised currently, but I will just pause and let people. Corky Kyle, you are unmuted. You are free to speak.
Hi there, thank you. I am, we got a little echo here, hold on. There we go. Yeah, I'm with the Colorado Coalition for Podiatric Reform, and just had a couple observations that I wanted to share with everyone to to further understand what's being done, particularly with the electronic prescribing. One of the things is how can we be assured that with the specific software program that we have on electronic prescribing, that we've got all of the database in there for all the big pharmacies, independent pharmacies, small pharmacies, all that. Are we sure that that information is all available so that we do have access of that information when we're out in rural Colorado, where we could be, several miles from the nearest Walmart or Walgreens or CVS or whatever? That's one thought that we had, and I just wanted to call attention to that.
Okay, thank you. We can certainly relay that to the board, as I'm definitely not an expert.
No, I know. It's just some thoughts. One other thing that I want to ask too, under 16.2 paragraph D, we talk about economic hardship. And I'm curious as to, after all this information is supplied, number one, where does the information go? And who are the qualified experts to make a determination as to whether or not there is an economic hardship on the part of the individual?
So I can answer that. All of the information, oh, sorry, I don't want to interrupt you.
Oh, no, that's fine. That was it. You know, and I know this is going to everybody else, and maybe we can get another answer at a later time. But I just find that interesting. I truly understand software these days isn't inexpensive. And if there is a small practice that's out in rural Colorado, obviously they have a different economic scale that they're working with on being able to maintain their practice. And updating their electronic medical records or updating their electronic prescription software, that can be pretty expensive. So I was just curious as to who's going to make the determination, what guidelines, what kind of experts, how is that going to be done? So if there is somebody that's concerned about that, at least they know how the process will go ahead and be managed should that information be submitted.
Yes, and so the information regarding economic hardship that's included in this rule that would be submitted, that would go to the board,
Okay.
and then the board would review it and determine whether there is an economic hardship.
But by whose standards then are they going to do? Every one of those board members all have a different set of economic philosophies, operating philosophies. And how is that going to be determined? I mean, it's pretty hearsay as to what it is. If somebody's making a lot of money and somebody's not making a lot of money, I can see where this could be. Well, this could be difficult at best to make a reasonable and fair determination on the part of the person that is requesting the economic hardship exemption. I mean, Denver County is going to be more expensive than Baca County, and vice versa. I mean, how are you going to know that? Just thoughts.
Yeah, I hear your concern. Do you have any thoughts on that and how to better make an economic hardship determination, how the board should?
I knew you were going to ask me that. I'm sorry, I only came up with the problem. But I would think that you would want to probably look at the area in which the individual resides. So if he's in Baca County, obviously you cannot use the same economic factors as if the individual is in Denver County. And I think you might want to address what the consumer price index is as it relates to those counties and any other economic information that might be there to demonstrate, what kind of conditions the professional's operating within.
Okay. Well, thank you for that. We can certainly relay that information to the board.
Cool.
Do you have any other comments on this rule or?
Nope, that was it. Those were just the concerns.
All righty, thank you. I'm going to go ahead and put you back on mute. AnnMarie Zuckerelli, I see that your hand is raised. You are unmuted. You're free to speak.
Hello. Hello.
We can hear you.
Am I in? Oh, this is AnnMarie Zuckerelli, and I'm with the Colorado Podiatric Medical Association, representing the majority of docs in the state. And I wanted to say that we had no problems with the rules as they were written.
All right. Thank you.
You're welcome.
I'm going to place you back on mute.
Oh.
Any other comments, questions, concerns? I don't see any hands raised or any written comments, so we'll pause here for a minute before we move on to the other rule that's up for feedback at this meeting. Alrighty, I don't see any more hands raised or anything like that, so I think it's fair to move on to the next proposed new rule. So this will be Rule 1.19, 19.1, required disclosure to patient's conviction or discipline based on sexual misconduct. Is there anyone? I see AnnMarie Zuckerelli has her hand raised. Let me go ahead and unmute you. You're unmuted again, so you are free to speak.
Hi, can you hear me?
Yes, we can.
Hello? Yes? We didn't have a
Yes,
problem with that either. We didn't. Colorado Foot and Ankle Society or the Colorado Podiatric Medical Association had no problems with this required disclosure.
Awesome. Thank you. I'm going to put you back on mute. And then Corky Kyle, I see that your hand is raised again, so you are unmuted on our end.
Yeah, no, thank you very much. I was just a couple of points. I wanted a clarification on 19.1 paragraph A. It says on or after March 1st of 2021. I'm assuming that this law only goes into effect on March 1st, 2021, and anything that happened previous to it does not, that has got nothing to do with this, but everything forward of March 1st, then this is what this rule would apply to.
So is your question, if you were convicted before March 21st, 2021, or you had discipline that would fall under this disclosure, that you would not have to disclose it?
Correct.
I believe that if you have had a conviction or any discipline, that you would have to disclose it under this new requirement, even if it happened before March 1st, 2021.
You're saying anything retroactive, still that this would be required.
That's my understanding. I can get clarification on that if need be. Okay.
Right. You might want to check that. Okay, that was my big question. Let's see what else. Acknowledge. Okay, a couple of things here. There's a little bit of clarification again as it relates to the timing of the disclosure and when it should be delivered and when it shouldn't be delivered, etc. And so it says there must be a disclosure agreement to treat, has to be completed prior to each treatment appointment with a patient, unless he's got multiple plans. So the question is, if I walk into the doctor's office and this doctor that I'm using does have a conviction or there's some discipline, before he starts to treat me, he's got to give me this Appendix A disclosure statement telling me all that before we can go forward with my treatment. Am I reading that right?
That is correct, yes.
Now, what happens if I get on the phone and make an appointment over the phone? Do I get it when I arrive, or does he have to email it to me, text it, mail it? What?
I think my understanding is that it has to be signed by the patient prior to the treatment.
So we just go ahead and wait until they showed up.
That could be, yeah. I mean, according to the way this is written, it's before the treatment.
Now, if I have multiple treatments that need to be done, I think I understand this, particularly in paragraph 2 of section C, that if I've got multiple, I only need to get one disclosure. If I've got 8 treatments and I've got 8 times I've got to come back, the doctor doesn't have to give me 8 disclosures. One disclosure for those 8 treatments will be sufficient.
Correct. That's my understanding. We had a question this morning in the massage therapy stakeholder meeting. So if you have a massage scheduled every month with the same massage therapist, as long as that's provided and signed by the client or patient prior to the first treatment, and there's a series of treatments after that, then one disclosure is sufficient.
Okay, got a question. Obviously, and I think I know what the answer will be, but anyway, I thought I'd ask it. This particular set of rules and regulations are coming off the 2 pieces of legislation that you included in the packet that you sent out to everybody. And I'm curious as to, there isn't a section as to where the healthcare professional has some understanding of what his rights may be in this type of relationship, or does that matter because that was done prior to the conviction or the other action taken by the board, whether it be probation or whatever?
I can't speak to the legislative intent and how the bill came to be, but I think you're correct in that the practitioner or the licensee would have had due process, either in the criminal court or in front of the board in this particular case, regarding the allegations made.
Is what we're saying. This is after the fact. This is after due process.
Yeah, and I can't speak to the legislative intent. At this point,
no, I'm
we're
not
just
asking you to.
implementing. So.
Yeah, no, I'm not asking you to. Okay. I think that's everything that I've got. Let me ask one more question. Let's say that the doctor is on probation. His probation ends. Obviously, then, does he still have to give disclosure statements after meeting the discipline that was assigned?
So the way it's written is it's based on the conviction itself. It's not based on the successful completion of probation. So if the licensee has been convicted,
yeah,
correct.
So that's got to be done from every time here on out.
Correct.
And with every patient.
Correct. And so, Elena, you can scroll up a little bit. It's under right here, D, because it talks about the conviction or the guilty plea to the sex offense or the professional regulatory, the misconduct there. So for each conviction or guilty plea, it's not contingent on successful completion of probation.
So in essence, even though the individual is satisfied the requirements of the probation as determined by the board and has done what he is supposed to do, that doesn't ever go away, even after satisfactory completion of that probationary period or whatever action. I understand the criminal conviction. I'm not even addressing that. I'm talking about board action as it relates to the doctor and having him satisfy that requirement. I know we're just talking sexual issues here, but I mean, if it's satisfied and then the person's done whatever they were required to do, it's sort of like, okay, I've done it, I've done my time, and this ought to go away. Obviously, I'm just curious because this just goes on forever. The guy might as well sell his practice and go be an auto mechanic.
Yeah, the way it's written, it's the finding. It doesn't go away. According to how I read this, it doesn't go away regardless of whether the probation or the practice monitoring or whatever it was completed successfully. Similar to like the public discipline would say, if there was public discipline imposed that required practice monitoring, treatment monitoring, or therapy monitoring, whatever it was, that remains on the licensee's record forever.
And so what happens if this was consensual between the two parties and somebody got upset one day and filed a complaint?
I can't speak to that. All I can speak to is what the requirement is. So what the legislative implementation is.
All right, well, I understand. No, that's good. Just curious, because if it's consensual, we're dealing with some different parameters and circumstances at that point. But I know that this is designed for after the fact. Okay.
All right. Anything else?
No, thank you very much.
All righty. I'm going to go ahead and place you back on mute and lower your hand.
Lower my hand.
Any other participants who want to provide any input, feedback, questions on this proposed new rule? I'll go ahead and wait another minute or two before we wrap up the meeting. Alrighty, I'm not seeing any other hands raised or written comments or questions, so we will conclude. Thank you for participating in today's meeting. The stakeholder comments and program recommendations will be presented to the board prior to the permanent rulemaking hearing, which is tentatively scheduled for December 4th, 2020. That concludes the stakeholder meeting. Thank you again for your participation, and we are going to end the webinar now.